Can you guys hear me and see me?
Yep,
Okay, you can see me also?
See you.
correct.
Okay. I don't see me.
Okay, we're going to go on the record. Good morning. It is 9:38 a.m. and I would like to call today's hearing to order. I'd like to reflect for the record that we do have a quorum present. As a matter of fact, majority of all the board members are present today. We have two individuals who are teleconferencing in. First is Verdugo Peralta over at Temecula City Hall. I would ask for the record, was your agenda posted and your location posted pursuant to the Brown Act?
Yes, it was.
And there's no other individuals over the age of 18 in the room with you other than Mr. Verdugo? Other than Mr. Peralta, correct?
No, no one else.
Okay. Dr. Abraham is also porting in remotely.
Yes.
Dr. Abraham.
I'm
did
requesting
notify me.
to participate via Just Cause for due to caregiver duties of a loved one.
Okay, and just for the record, Dr. Abraham did notify me yesterday. He sent correspondence, and of course, I communicated back with Dr. Abraham relative to his obligation in accordance with AB 249, for which he just provided a general description of the circumstance justifying the need to participate virtually. Dr. Abraham, are there any individuals in the room with you?
No,
And just for the record, he's participating via camera. We can see him. Members of the public are also available to participate remotely. And which is a great segue. Madam Clerk, are there any individuals online via telephony or Zoom connection desires of providing any public or evidentiary testimony, general public comment, et cetera? Let the record reflect that there are none. Today, there were initially three matters scheduled. Those matters have been removed from the calendar. That was the Irvine Ranch Water District case number 6211-2, interim variance off calendar. The other case was Southwest AQMD versus Flex Firm Holdings LLC 6239-1 status report modification order for abatement rescheduled to tend to December 10th, 2025. The matter before the hearing board today is a matter that's on consent. Chevron Products Company case number 831-408. Regular variance rules 203, 2004, 2012, and 3002. The hearing board will consider whether to grant a variance of more than 90 days. Before the hearing board, there are multiple exhibits. Petitioners exhibits, joint stipulation to place matter of consent calendars. Exhibit 1, declaration of Andre West, first name Andre, last name West for Chevron Products. Exhibit number 2, proposed variance granting a regular variance is exhibit number 3. There are no responded exhibits. There is a hearing board exhibit, an email exchange between board member Balakapalan and parties. That's HB1. All right, members of the hearing board, any discussion, deliberation, perspectives, opinions? Mr. Balakapalan.
Yes, this, and members might recall that it was on the news that the Chevron facility had a fire explosion on October 2nd, I believe. And these two units that the ISOMAX 720 and the 731 have been affected by it, as well as from my communication with the parties, that also the SCR system was also affected by the fire. So they're both out of
For him. There's a vote required for just cause under the care of a loved one?
Yes.
Okay. All right, no problem. Place the matter. I didn't believe we needed to take a vote on this, but okay, no problem. I'd like to place a motion on the table allowing Dr. Abraham to participate remotely via just cause. I second. It's been moved by Ali, second by Mr. Pearman. Any further question or discussion on that motion? Hearing none. Dr. Abraham, I assume you're going to abstain. Ms. Verdugo
Correct.
Peralta,
Yeah, right.
Mr. Balakapalan.
Yes.
Mr. Pearman.
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. All right, Balakapalan, the floor is yours.
As I was saying, this facility experienced a fire at the Isomax unit on October 2nd, 2025. So the heaters were affected as well as the control system. The reason they're before us is because there are some permit requirements that require them to do testing do a radar testing and ammonia slip testing, which all of which they cannot do because of the units are not in operation. So the heater is out of service for now. They're repairing it, I assume, as well as the SCR system, which also is out. So the SCR system, as you know, it's where they inject the ammonia to do the ammonia slip testing. You need the SCR in operation, as well as, to control those emissions of NOx and CO from the operation of the furnaces. So they are unable to conduct the tests. And that's why they, as required by the permit condition 82.18 and, D 82.18 and D 29.29. And that's why they're requesting relief, a variance for almost a year, because it will take some time to repair those damaged units. While they did not disclose, I guess the investigation ongoing as to what caused the fire. So that's beyond our scope for this hearing. So I do believe they met all the necessary 6 findings. They're in violation of specifically conditions 82.18 and D 29.29. What happened is beyond their control. It was a fire at the Isomax units. So 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 during this time, the closing would be. I mean, there are no emissions because the units are not in operation. So there are no harm to the environment, and there are no excess emissions. So there's nothing they have to do to reduce the excess emissions, so to meet the other conditions. So they basically have articulated all the reasons why they make the 6 findings, and I agree with that. And I believe I can make the 6 finding. I mean, I can make the motion at the appropriate time to grant the regular variance.
All right, any additional deliberation?
Yes, Mr. Chair, I do have
Asking
a
for, is
couple
it-
of comments.
Okay, Mr. Pearman, the floor is yours.
They're asking for the time until September 30th?
2026, yeah.
Okay.
Ms. Verdugo Peralta?
Thank you, Mr. Chair. One thing in reviewing all of this, and because it was on the news because it almost affected quite a few people, there was, from my understanding, a whole Edison crew that was out there 10 minutes before it blew. Is the root cause analysis. Well, I know that's not within our purview today. I just want to make a notation that when this comes before us again, and I think that it will, because I'm not so sure that that's going to give them enough time to do all the work that they need to do. It's quite involved, that we have some type of response from them regarding the root cause analysis, because I'm hoping that this will never happen again. But, with a refinery, it's probable more than preventable sometimes. So that's my only comment going forward. I will go ahead and I will vote for this, but I just want us to be aware of the fact that hopefully this repair will indeed be a full repair and there won't be another incident like this.
All right, any further questions, comments? All right,
I can just add that I too can
Go right ahead.
support this regular variance and, reviewed the stipulated order and also can support the motion.
all right, Mr. Balakapalan, did you want to make the motion or did you want to add anything
Yeah.
supplemental?
So in the matter of Chevron Products Company, case number 831-408, I move that we grant a regular variance commencing today and carried on to September 30th, 2026, from the following rules and subsections. So it's Rule 203B, 2004 F1, 3002 C1, 2011 F6, 2012 H6, and permit conditions D 82.18 and D 29.29 for the facility located at 324 West El Segundo Boulevard. The affected equipment are the two heaters that's listed as D641 and D643, device ID D641 and 643, the facility permit, and also I'm going to include the SCR C4523. Those are the devices affected by this variance, since they're not in operation and they need time to repair it. The conditions as set forth in the revised order, which included permit conditions include D 82.18 and D 29.29 that was added. And there will be no excess emissions because the units are not in operation. So don't expect any excess emissions during the period. In fact, there will be a negative, a reduction in emissions because they're not operating. And that concludes my motion.
Second.
All right, it's been moved as a second by Ms. Verdugo Peralta. Any further question or discussion on that motion? Hearing none, Dr. Abraham.
Aye.
Ms. Verdugo Peralta.
Aye.
Mr. Palaka-Palan.
Aye.
Mr. Pearman.
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. Just one comment I just want to state. I believe that the emergency circumstances requires a vote of the board, not just cause. So there's a distinguishing difference between just cause and emergencies. Just so we don't set a precedent.
Wasn't he doing already?
He's using just cause, not emergency, because there are two.
Right.
There are two. So just we can do some research and come back, but I don't want to set a precedent and then we have to. And yeah, so under emergency circumstances requires that action may be taken by the board, but under just cause, I don't believe that that AB 2449 requires the board to take a vote. But we can research it. I want to make sure that we're in line.
He didn't care completely, but it wasn't because mom was sick.
Yeah, he's caring for a loved one.
Okay, so that's under emergency though.
No, he stated just cause. He didn't say the emergency.
Yeah, but I think that falls under the emergency provision, but just causes are different.
No, just cause is caring, is child care, parent, grandparent, sibling, spouse, domestic partner that requires them to participate remotely, contagious illness, etc. So we can research and come back. All right, folks. We're adjourned at 9:51 a.m. and off the record.
Thank you.